The first matter is Jonathan Peters versus the Workers' Compensation Appeal Board, Cintas Corporation. Representing Jonathan Peters is attorney Daniel J. Siegel. Representing appellee Cintas Corporation is attorney Kathleen C. Pocatino.
Good morning, everyone. We welcome all of you to our September session, held as in May remotely in light of the continuing public health guidance. Council, I think, have been fully briefed on the protocol for this session. I'll remind everyone, as I think Brian had, that I'd appreciate a minute to frame the issues in the cases that will be argued today, and then we'll turn to each council in turn for opening statements. I would also ask you, as the justices have an opportunity to pose questions to council, that you endeavor, in light of the remote aspects of this, to focus your attention on the justice asking the question. And as always, remember that we have access to your briefs so that we're fully cognizant of all the issues, in most instances, a discrete issue. The first case has been called, and this is a workers' compensation case in which a claimant is a sales representative who was required to travel for work. After being injured in a motor vehicle accident, the claimant sought workers' compensation benefits. The case presents a unique factual scenario which may aid in clarifying the circumstances in which a traveling employee will be deemed to be acting within the scope of his employment, thus entitling him to benefits. Mr. Siegel.
Good morning, members of the court. May it please the court. I'm Dan Siegel on behalf of Jonathan Peters. Also present with me is Alexis Berg, who had handled the matter in the lower courts. This case is somewhat unusual and also somewhat not unusual in the sense that dealing with traveling employees, as Your Honor indicated, do not have a fixed place of work, is a very common situation in Pennsylvania and throughout the country. This court has never had the opportunity to determine the standards, however, until this case, for traveling employees in terms of what is the definition of a traveling employee, what are the standards that apply to determine what is a compensable injury. Traveling employees are somewhat unique in the sense that, unlike typical workers who work from a location and can suffer an injury, traveling employees are those employees without a fixed place of business. And the standards that have been applied to this time by the Commonwealth Court have all focused on the fact that once an employee who is a traveling employee begins his or her travels, that entire process continues and is furthering the employer's business activities, whether they are a traveling salesman, someone who has to travel out of town, etc. This case presents the situation where an employee was injured on his way home from a social event and allows this court, as per the questions that have been raised, as to what constitutes abandonment of employment. What we have done and what we have proposed to this court are essentially three concurrent standards that would create a consistent analysis, whether in this particular case or in any other case involving traveling employees. We suggest that the court first define traveling employees as any employee who has to travel from place to place away from typically a permanent residence or the employer's place of business, when such traveling employees would include from when they begin their trip until they arrive home, unless there is what has been called an abandonment of employment. And that's really the central issue here. We propose that and consistent with many of the Commonwealth Court's cases, that abandonment of employment would have to be a distinct break from the activities that would be done by the employee, as opposed to temporary departures for anticipated things such as personal comforts, non-employment related events, and also where you are attending an employer-sponsored event, whether voluntary or not. And then, as has been applied typically in the Commonwealth Court and in other jurisdictions, as set out in Judge Jubilier's dissent in the Commonwealth Court, an employer would have the opportunity to rebut the presumption that it's work-related by demonstrating that it was such a break in the activity as to remove the employee from the course of employment.
Counsel, this is Justice Baer. Let's assume for right now that your client was a traveling employee. Mm-hmm. I think the initial question is whether he should gain advantage of the presumption. And it seemed to me, and it was difficult to discern, as you say, there's none of our cases, and the cases are sort of everywhere. But at least as I perceived your opponent's brief, that the underlying purpose of the doctrine was when the employee was deceased and could not testify to their motivations, the presumption arose out of fairness to them because they were traveling. Here, your employee survived and is able to testify that I was not going home, that I felt obligated to go to this party, or conversely, that I just felt like going to get a drink, which obviously he's not going to say or we wouldn't be here. So does the presumption make any sense when the employee is free to go defend himself with counsel at the hearing?
No, Your Honor. The traveling employee doctrine should apply regardless whether it is a fatal claim or a claim such as this. The rationale behind that is when travel is an essential part of the employment, such as in this case for a salesman, the risk of injury, of being injured, whether in whatever means, is incident to that employment. And as long as the employee is still within the continuum of performing or on the travel for the employer, it should apply. We don't believe that the standard or the suggestion that it must be a fatal claim is appropriate. There's no such suggestion in the Act, and in fact, Section 301 of the Act specifies that injuries can occur off premises and makes no distinction. Moreover, to accept the employer's arguments, this court would also be vitiating the traveling employee doctrine and creating the test that applies to an office-based employee, which is simply furtherance of an employer's business. When courts have looked at, primarily the Commonwealth Court, that standard, they have determined that while you're in the continuum of being a traveling employee, all of those activities are furthering the employer's business unless there is such a break as to contact.
Can I follow up for a second? Did you, well, you or your colleague who's with you represented the claimant at the WCJ and WCAB. Is that accurate?
Yes.
Well, I noted that neither of their opinions got into the traveling employee or continuing work presumption. I thought that was interesting because we presume that they have greater expertise in this matter than does our court or the Commonwealth Court. Do you have any insight? Was it not did you not raise it? Did the other side not raise it? Did they conspicuously reject it? But what happened here that neither of those tribunals opined to it?
Well, if you look and at the appendix of page 10, you will see that the workers' compensation judge in his findings of fact said, and I'll quote, "It is acknowledged that claimant is considered a traveling employee and therefore consideration is given to that presumption, et cetera, et cetera." The WCAB also acknowledged that he was a traveling employee, as did Commonwealth Court. That was the central distinction. The problem was that there was an analysis done that primarily looked at social event cases rather than traveling employee cases. But clearly, when you look at the matter before the WCJ, as I quoted, acknowledged that he was considered a traveling employee. That was not in dispute.
When I started my first question, I said, let's assume for our purposes he's a traveling employee.
Yeah.
The issue of whether he gets the presumption is discrete from that. He could be, as I posited, and I'm asking because I don't know. I mean, I'm not trying to badger you. He could be a traveling employee, not deceased because of this accident, thank goodness, and therefore not entitled to the presumption. Or conversely, a deceased traveling employee, a little bit like the dead man's rule, who, because he's deceased and can't testify, well, I felt obligated to go to the party. I drove by my exit because I was trying to get there as fast as I could, and on and on and on. So because you arguably just get into a credibility determination in whether this is a frolic or detour or a continuation of work, you don't need a presumption. Well, it's the last time I'll ask you, but again, I think it's the central point of the case.
Well, I think the presumption should apply, and that's the test that we propose to the court, that the presumption applies and then may be rebutted, because as much as you can have a test, it will always come down to a determination by the judge as the fact finder whether whether an employer has rebutted that presumption, whether the evidence is sufficient. But the distinction between whether an employee lives or dies is a distinction that is not consistent with any of the case law or any other states that have addressed this. They look at it as the employee suppose I'm a traveling salesman. Once I leave my house today to go on my route and stop at the different businesses, I am still presumed to be the traveling employee until I get home and end my route. Now, if during that time I decide to abscond and go to a motel with someone or something like that, that's a discrete break from the work that would presumably be the rebuttal that the employer would present. But
Mr. Siegel, it's Justice Todd.
Yes.
It seems to me that referring to where this traveling employee was headed as a party and as making him have a break in his employment does not make sense in a situation where, as here, the employer was, in a sense, sponsoring the social gathering, providing, paying for a drink, providing and paying for appetizers. Isn't there a true distinction there that distinguishes this case from any case where, a guy just stops for a drink?
Yes, Your Honor. That's the point. In this particular case, and while there's been a lot of discussion about whether it's voluntary or involuntary, the dissent addresses it well in the Commonwealth Court, that he went to an event that was an employer event. Whether it was mandatory or not, the supervisor was there. He went directly from work. The company paid for all of the refreshments, food, drink, whatever was used on a company credit card. And from there, he began his travels home when he got into the accident. That's all within the continuum, sort of the reasonable continuum that has always been done. What's happened here is that a standard was added essentially by Commonwealth Court that said he passed his exit for his house. Well, if he had not passed the exit because he lived 20 miles further, theoretically it would have been compensable. That's not a distinction that has any sort of rational basis.
Mr. Siegel, maybe I'm not quite understanding this, but in terms of the Commonwealth Court's analysis regarding the exit for his house that he passed, but let's say hypothetically that the employee did go home, did stop at his house, changed his clothes, and then went out to an employer-sponsored event, such as the one we're talking about here. I'm not sure I understand why that would make a difference. It's still not an abandonment, is it?
I don't believe it is. It's no different than if he did that at work. Well, I'm done my day of work, so I'm going to take my suit off, put on a sweater and some khakis. I don't believe that takes him as a break from employment that is discrete and distinct, as opposed to the example I gave or many others we could create. I agree.
Even if it is a break in the employment, or the break in his continuum, rather, doesn't the continuum arise again? Doesn't the working relationship arise again if he is independently then changing his clothes? Okay, that segment of my day was over, but now I'm doing another work-related event.
Yes, it does. I agree.
Counsel, this is Justice Doherty. Now, you indicated that the employer paid for all the drinks, but my understanding of the record was that the employer only paid for one drink as well as the appetizers. Assuming that the employer only paid for one drink and left, and your client remained, do you find that to be a distinction such that he abandoned the work since he now has left or remained at a bar separate and apart from, as what Justice Todd calls a work function?
No, I don't. The fact that whether he stayed or not is not a factor here. He was at the work event in his course of his work and then proceeded home. Whether he stayed for a drink or anything else does not constitute a break, and certainly wouldn't be an abandonment of his employment, which has traditionally been viewed as something very distinct and separate, and that's not the case here.
Counsel, it's Justice Donahue. Could you do me a favor and tell me what the result here would be in the facts most favorable to you, an employee-initiated event, if the employee was not a traveling employee, but instead went across the street to the social gathering and then went home and was in an accident?
If this were not a traveling employee, and he or she is injured at the event, that is compensable. But if they're not a traveling employee, they are subject to what's been called the coming and going rule, which essentially is an injury is not compensable while commuting. So that injury would not. And that's consistent with...
That's where the presumption comes in, does it not? That's where the presumption plays its most critical role. The presumption takes the employee who is a traveling employee back to his home before his workday is concluded. Am I understanding that correctly?
Yes, the presumption is different and essentially more extended because of the nature of the employment as a traveling employee. Yes or no?
So it gets him back home?
Yes, but not the person who just goes to their computer.
Correct.
Counsel, question, a follow-up. Would a remand be necessary to explore what went on after Smith and Cintrone left, after the tab was paid and they left, and your client stuck around? The record doesn't seem to speak to what was going on, and perhaps that lacuna there informed the lower court's finding that of abandonment. I mean, would there come a point in time that a traveling employee staying on at a bar, drinking a few more rounds, for example, or even going to some other bar and having a couple more drinks would break the chain here?
Well, I don't believe a remand is necessary. There was an ample factual record developed by counsel in both parties as to what happened, from which the judge made, the workers' compensation judge made findings. There's simply nothing in the record presented by anyone that evidences an abandonment or other conduct that would take this out of the continuum of a traveling employee. I don't believe you need to remand. I believe it would be a reversal here for an award of benefits.
Mr. Siegel, Justice Todd again.
Yes.
Following up on Justice Weck's question, would you agree that in that hypothetical scenario where all the work colleagues left, the boss left, the tab was paid, and the employee stayed another hour or so and became inebriated, that there is a break in the continuum?
It is possible, depending on the facts, yes, but those facts aren't here.
I understand. That's why I said hypothetically, but
Yes.
I'm just trying to see, will you acknowledge that there can be a break midway through the work-related activity?
Oh, there could be. I mean, and both parties' briefs highlight all the different cases with all the different types of breaks and events that could happen. This is far more traditional that, you know, there's an employer event, the employee goes to it, and then from there, he goes home. This is almost the simplest scenario because we don't have all of those what ifs of the types of things that would make all of us say, well, maybe. There's nothing here that creates that maybe or that concern of a break or an abandonment.
Mr. Siegel, Justice Baer, and again, I'm following up on Justice Wecht and Justice Todd. And I don't typically like to do this because we're getting into the facts, and we're a court that tries to establish legal tests. But, and again, I come back to where I sort of began after I prepared. Your client's alive, your client testifies with counsel. The WCJ, listening to the stories of all as to when your client arrived, when the employer client supervisors left the bar, which I think was 45 minutes or so before your clients arrived, how long your client stayed, et cetera, makes the factual determination that your client was there, not improperly, but having a personal drink with some friends, watching Monday Night Football, and not there for the work program. The WCJ surely has the right to do that on contested facts. Does that then overcome the presumption?
I don't believe it does here.
Okay.
What we have here is a situation where he's still within that continuum. And what happened here more so is that the WCJ did not properly apply the law, or the law as we are suggesting this court should clarify, to these facts, but that the facts remain of the type that there was no abandonment of employment. There was no discrete break that took him out of anything that would be foreseeable. People go to restaurants and bars all the time, and you know, in social gatherings, they don't typically everyone leave at the same time. Some linger, some talk, and that's part of the desire often of an employer that you build a collegiality, or that someone's just resting. If he had a long day, he might want to rest and watch a game, but it doesn't constitute a break.
Counsel, can I ask how you would like us to define the type of event that's necessary in order to have the continuum of employment? Either you or one of the amici refer to an employer-initiated social event. Does that aptly describe the context of the type of gathering that would qualify as not an abandonment?
Yes, it would not be an abandonment.
Employee initiated social event.
Okay, and if it's employer
initiated, I'm sorry.
Yes.
I did that. Thank you for correcting me. An employer initiated social event. Does that aptly capture the situation we're talking about?
Yes, that's this situation here. And that's what we had here. It's very different from if, let's say, I and 3 colleagues decide at the end of the day we want to go out and have a drink or go, for dinner. That's not an employer's event.
I understand that, but I'm trying to capture the appropriate description. An employer-initiated social event has nothing to do with voluntariness or involuntariness. It's the fact that the employer initiated the event that is the critical point.
Yes, Your Honor.
Mr. Siegel, it seems to me that standard that Justice Donahue is asking you about is really a subset, a substandard of what Judge Cohn-Jubileer said in her dissent, and she restated the well-used, well-understood standard that the employee's actions were so foreign to and removed from his usual employment that they constitute an abandonment of that employment. Is that the standard that we're still applying?
I would suggest yes. I believe the dissent was correct. And had it been the majority, we would not obviously have sought aliquotter.
Thank you, Mr. Siegel. We'll hear now, please, from counsel for the appellant or the appellee, Ms. Pochettino.
Good morning. May it please the court. My name is Kathleen Pochettino, and I am here on behalf of the Aplt Cintas Corporation. I want to kind of phrase the discussion in reading a book. We start at chapter 1 of a book. We start at the first chapter. The first chapter of this book is Section 301C1 of the Workers' Compensation Act. And that provides that for an employee to be in the course and scope of employment, they must be in furtherance of the employer's business or affairs. Starting our analysis and our discussion as to whether or not the appellant was a traveling employee is starting our book at chapter 6. The Workers' Compensation Act is always where we start our analysis in these cases. And that's why the WCJ and the WCAB started their analysis there. What was the appellant doing at the time of the injury? What was the incident that gave rise to that accident? Here, he was traveling, commuting between a non-mandatory social event. And I think to call it employee-sponsored is just another way of saying that the employer-sponsored was that the employer paid the tab. The facts that were found by the WCJ was that this was not mandatory. It was voluntary. It was a business meet. It was not a business meeting. It was a gathering for chit chat and to wind down at the end of the week. When you take those facts into consideration and starting at Section 301C1 of the Workers' Compensation Act, you get to the conclusion that he was outside the course and scope of employment. Looking at the case law that defines and describes that section of the Act, you see that the court has come up with various descriptive terms. But ultimately, at the heart of it is whether the appellant was in furtherance of the employer's business or affairs. Commuting or driving home from a social event is not within the course and scope of employment.
Counsel, I'm sorry, are you done with your summation? I don't know if it's been 2 minutes. No. The difficulty, and I wanted to see if I could direct you, Justice Baer, is that you're arguing the facts of the case. That's really not our court's function. We're interested in whether we should, in fact, adopt the presumption, whether the presumption is applicable here, whether the presumption controls notwithstanding the facts here. I just wondered if you could turn your attention to that and not ask us to get in the question of whether or not the WCJ, WCAB, or Commonwealth Court erred in terms of their factual findings.
So the analysis, and Justice Baer, you asked this of Attorney Siegel. why did the WCJ and the WCAB have a different focus in their opinion from the Commonwealth Court? And I think that that's the heart of this case. You don't get to the presumption that someone is a traveling employee until you make a determination as to the facts surrounding the incident. There is no 24-hour continuum that once you leave your house for work that you're continuing working. And you can see that in the cases that discuss business trips, out-of-town business trips. So for that presumption of the traveling employee to apply, there has to be first a determination as to course and scope of employment. And it comes back to Section 301 of the Act. So he was commuting. He wasn't working. He wasn't driving from a meeting. He wasn't driving from a business meeting. He wasn't driving from a sales call. He was commuting from a social event. And that goes back to the coming and going rule, which excluded commuting. And in reading the cases and in using the term traveling employee or abandonment of employment, I think they're just buzzwords or descriptive terms to get really to what the heart of the issue is in furtherance of the employer's business or affairs. Commuting event is not in furtherance of the employer's business or affairs.
So can I take, this is Justice Baer again, so can I take it from your considered view of the case that if we decide that upon reading very carefully, which has to await post-argument, the record in this case, that he was under some compulsion, even informal compulsion, to attend the event because he was invited by a superior. And I don't know your situation, but you're in a big law firm, and your senior-most partner says, well, why don't we go have a drink tonight? And you don't feel free to say no to that, even though you didn't want to especially go. So you go. So he was in that kind of scenario. And if we decide that, then you would concede that you don't prevail in the case. Your whole argument is that the coming and going rule is applicable and that he was out with buddies for a drink that had nothing to do with work. Is that correct?
Yeah, he was
okay.
driving. Yeah, he was driving home, and it had nothing to do with work.
Fair enough. Thank you.
Counsel, it's Justice Donahue. Can I follow up on that? You would then argue against this court holding that an activity that is in further of building good relationships between the employer and employees is in furtherance of the interests of the employer and therefore within the scope.
So the WCJ noted in his opinion that there is a separate line of cases related to those social events that can be found to be work-related. The WCJ references the Tredyffrin case.
And Kelso is also one of those cases.
Right.
Kelso is also one of those cases. Do you agree or disagree with that proposition?
I'm sorry, I couldn't understand what case you said.
Kelso, and the case that you cited, the notion that if the activity is in furtherance of good relationships and promoting a good healthy workplace, that is within the furtherance of the interests of the employee and is within the scope.
Correct, but that's a factual determination that the WCJ makes as to whether that social event is work related. And
well, you're stating it differently. I mean, if we say that if an event is sponsored by the employer and its end is to promote good relationships between the employer and the employee in a good workplace, then the workers' compensation judge would have been wrong. This was initiated by the employer, was it not?
Mr. Cintron, the manager at the time, did invite the other employees to gather at the Tilted Kilt on that evening. That is correct. But in making a determination as to whether a social event is work-related, there's a multifactorial sort of indicia test in the underlying cases that make that determination. And those cases that find work-related injuries at social events are injuries that occur actually at the event. And Mr. Siegel commented on that, noting that only those injuries that occur actually at the social event are within the course and scope of employment and not necessarily.
But counsel, that's why there's a presumption for traveling employees that they're working until they get home at the end of whatever the day encompasses, including an employer-sponsored social event, or I should say an employer-initiated social event. That's where the presumption comes in, getting back to Justice Baer's questions.
The presumption should only apply when someone is in furtherance of the employer's business or affairs. So
okay. I understand your point. Thank you.
Thank you. Could I just ask a question? What in the world does it have to do that you get to this event he drove past the exit to his home?
that was determinative for the Commonwealth Court as to.
How could that even be a factor? What would that have to do with anything? If it's assuming it's an employee event, you have to get there past the exit to his home.
So the Commonwealth Court outlined in their majority opinion that the return trip is part of the business trip. And so they were relying on the case law in Maurer and Oakes to say that the return trip from the business event is still within the course and scope of employment. So if we're strictly applying the door-to-door principle of the traveling employee doctrine, he had passed his home and was no longer within the course and scope of employment.
But could I follow up on the Chief Justice?
Question. Justice Bundy, I think, has a question.
I'm sorry, my question was answered, Chief. Thank you.
Thank you.
Could I briefly follow up on the Chief Justice's question with regard to that exit comment by the Commonwealth Court? I also don't see how that accounts for the possibility that he was simply traveling to a gathering in furtherance of his employer's affairs. And it suggested to me an entirely gratuitous comment, just as gratuitous was the comment that his wife was out of town and that his children were home. I mean, what does that possibly have to do with the question before us, which was whether this event was in furtherance of his employer's affairs?
The underlying case law on the application of a traveling employee doctrine is highly factual. And you can see that when reviewing all of those cases that the facts matter. And I understand that this court isn't here to rule on the facts, but in application of the law, the facts do matter because work activities and business relationships are not, clear cut, and bright line rules don't always apply. So it was really important to consider all of those facts. And so when reviewing the underlying case law, the Commonwealth Court noted that a distinction was made that the return trip was part of the business trip. The return trip had ended.
Do you agree with me that if we determine that this gathering, the Tilted Kilt, organized by Mr. Cintrone apparently, was in furtherance of Cintas's affairs, it doesn't matter if he drove past 10 exits. It doesn't matter if there were 20 kids at home or if his wife was in Madagascar. You agree with me?
I don't think that I agree with you, because I think that the WCAB found the facts and they're not on appeal. And the facts that were found were that there was no material benefit to the employer. The appellant went because he wanted to go. It was voluntary. It wasn't mandatory. There were no work-related discussions. It was just chit-chat and wind down. So
are you suggesting we prescribe a test that the WCJs have to go out and measure whether there's a material benefit to an employer or not? How are they going to possibly measure that?
by looking at the facts of the case. Whether there's a material benefit to the employer is based on the appellant's testimony and the employer witness testimony. And in this case, you take all of those facts, you add them together, and you come to the deduction that there was a material benefit to the
I
employer.
think the very purpose of these types of gatherings, not a material benefit, but an intangible benefit, as some of my colleagues have suggested in their questions. Building collegiality, for example.
I don't dispute that that's certainly a possibility, but that wasn't the case here. There wasn't any evidence or finding of that.
Thank you. Any other questions?
Chief, can I add, this is Justice Barrett. I just want, just very quickly, you mentioned in your oral argument, Mayor, which was a Superior Court case, and Oaks, which was a Commonwealth Court. Were they correctly or incorrectly decided in your estimation?
In terms of the ultimate holding or the rationale?
I don't care.
Okay. Maurer, I think, was decided correctly because, as I outlined in my brief, Maurer was a fatal claim and he was deceased, and there was a reliance on this Wolfenbarger presumption. Oaks, similarly, I think was found properly because he was on his return trip home from his business events.
All right. Thank you for that very much. Chief Justice, thank you.
Thank you. Thank you both counsel. That'll conclude argument in this case. We'll take up the next case in 5 minutes. Ron, you can call the case.
The next matter is in re appeal of Coatesville Area School District. Representing appellant Coatesville Area School District is Justin D. Barbetta. Representing the Board of Assessment and Appeals is Jonathan Long. Representing appellee Houston Properties is John Fiorello.
Good morning. Res judicata precludes the relitigation of issues that have been conclusively decided in prior litigation when certain conditions have been satisfied. The court allowed appeal in this matter to consider whether the Commonwealth Court erred in applying the doctrine to dismiss an appeal filed by the Coatesville Area School District. Mr. Barbetta.
Thank you, Chief Justice Saylor. Good morning, Your Honors, Mr. Fiorello, Mr. Long, and may it please the court. I am Justin Barbetta, and I do represent the appellant in this matter, the Coatesville Area School District. This morning, I will be arguing points related to technical res judicata and collateral estoppel, as well as points related to the backdrop of the tax assessment appeal laws in Pennsylvania. I did want to make the court aware of the fact that I will be splitting time with Attorney Long, who will be making points related to judicial economy. We have approximately 100 years of jurisprudential guidance from this court related to technical res judicata and collateral estoppel. And there's really two major points that come out of that guidance. Dating all the way back to 1920 in the state hospital for the criminally insane case that was cited in our brief. First and foremost, the preclusive effect of both technical res judicata and collateral estoppel has always been meant to prevent the harm or the evil of a litigant in one case coming back before the trial court in a second case and initiating some type of a proceeding, whether it be a cause of action, a bill, or a petition. And in this case, that is absolutely not what we have, as the matter was dismissed after being perfectly appealed to the Commonwealth Court. Another point that comes out of the jurisprudential guidance that we have in both the technical res judicata and collateral estoppel forums is that the court has always considered the appellate process to be part of the litigation, and if and only if that appellate process is concluded, at that point is when res judicata or collateral estoppel would attach and have a preclusive effect. I don't have much to say other than that the cases cited by both parties allude to both of these points that I'm making to you. And as it relates to the arguments related to the backdrop and the fact that a point was made that the backdrop of the tax assessment law in Pennsylvania necessitates application of res judicata or collateral estoppel. I would rely primarily on the brief that I filed, but the Judicial Code at Section 706 and the Rules of Appellate Procedure at 2591 do provide guidance on what a trial court is supposed to do upon issuance of an order from an appellate court.
Thank you. Any questions?
Justice Donahue. Could you describe for me your understanding of what are the consequences of this appeal that was taken on the other matters in the lower court that deal with precisely the same assessment?
Well, what I can tell you, Your Honor, is that what I'll call the school district docket, that was properly appealed to the court, and what I can also say is that res judicata should not have a preclusive effect on that appeal, and collateral estoppel should not have a preclusive effect on that appeal, as it was perfected in accordance with the rules of appellate procedure. The fact that there is another trial court docket that exists, well, that was not appealed, and the named party in that case, the city of Coatesville, chose not to appeal that case.
Well, counsel, let me ask you a broader question, because I think there's a significant relationship between the fact that there are other pending cases involving this same assessment still sitting in the trial court with a now final judgment. And so my question to you is this: is an appeal by one taxing authority of an assessment an appeal as to all taxing authorities as to that assessment?
The end result would be that all taxing authorities would be impacted by the result of an appeal.
I understand that, though, but my question is a little bit more technical than that.
Sure.
Once an appeal is filed by one taxing authority, does that act as an appeal of that assessment by all taxing authorities? Your argument in your brief seems to be that, well, obviously, this court or the Commonwealth court would decide that the trial court was incorrect. Well, obviously, all of those other cases are going to be controlled by that decision. Well, more precisely, what you're arguing then is an appeal by one taxing authority is an appeal as to all taxing authorities. That also answers the res judicata question. I mean, an appeal is not a relitigation, it's just an appeal, but res judicata collateral estoppel never enters into the even farthermost limits of one's mind if an appeal by one taxing authority acts as an appeal as to all taxing authorities on that same assessment. Is that true?
Well, frankly, Your Honor, I mean, the opportunity to file an intervention was present. And that's worth noting for the court that one of the arguments is that because the school district at one point filed an intervention in the city's case, it thereby had some obligation to then appeal that docket as well. I would note for the court that pursuant to the local rule, that was an untimely appeal or an intervention in the first place. And I did reference the Churchill case in my brief regarding the fact that the rules of civil procedure do not apply in the tax assessment world. But to ultimately answer Your Honor's question, in this case, there's two separate dockets with two separate entities listed as the named party in the docket. And each of those entities had the opportunity to file their own appeal. And in our docket, the school district's docket, we did so. So what I can tell you is that because our appeal was perfected, we should not be barred from having the decision made on the merits because we did not file an appeal in the city's case.
Okay, thank you.
Okay, thank you, Mr. Barbetta. We'll hear from Mr. Long.
Thank you. Can everyone hear me? May it please the court, my name is Jonathan Long and I represent the Chester County Board of Assessment and Appeals. Our argument primarily addresses the issue of judicial economy. It's obvious from the long drawn out nature of this matter that there's strong disagreement amongst the parties regarding the merits of the taxpayer's claim for exemption. And due to the nature of tax assessment appeals, if this matter is not allowed to proceed to the Commonwealth Court to be decided on the merits, it's a virtual certainty that it's going to end up back before our board and then work its way through the appellate process again. So therefore, it makes sense that it should be allowed to proceed to the merits of the Commonwealth Court in order to provide some finality in this matter. It's been pending for 7 to 8 years before the courts. The matter is fully briefed on the merits. It was prepared to be argued on the merits before the Commonwealth Court. So the board's position is that it should be allowed in terms of judicial economy.
Mr. Long, Justice Baer, and respectfully, why is it, I'm not sure I care much about your position, but why is it a virtual certainty that it will end up back before your board? I think the Commonwealth Court was trying to engage in judicial economy by saying this case is over because the appeal was untimely or was barred by res judicata, by preclusion principles. So why is it coming back?
Every time the tax assessment, every year, basically, it comes back up, and every party or the various parties have the opportunity to appeal the assessment again. And because it hasn't gone through the final full appellate process, the parties would then again have the opportunity to bring it back before the trial court. And if they don't like what the trial court said in that regard, they could then again appeal it. So it being allowed to go on to the Commonwealth Court and the Commonwealth Court having that say, in our position, it's our position that would provide much more finality on this. And then further guidance to other courts.
So if the Commonwealth Court decides this for, and I don't remember what tax year was involved here, but let's just say for 2015, and it's sort of an interesting corollary. You're not suggesting that there's res judicata or collateral estoppel for years 2016, 17, 18, 19, 20. If somebody wants to take a new bite at the apple, aren't those new cases?
Technically, in a way, they are. However, if the Commonwealth Court has gotten to the merits of whether or not this person really deserves an exemption, I think it becomes much harder for one of the parties to come back and say, well, Your Honor, to the trial court, we should get this again, or we should not, or they should not get this again. There provides some guidance.
Okay, thank you.
Thank you. We did have a few points on res judicata and collateral estoppel. Basically, the board's position is that in order for those doctrines to apply, judgment has to be final. While the prongs of those various doctrines seem to be met for the most part in this case, as this court has said, judgment needs to be final. That means that the appellate process must have gone through, and there needs to be a final and conclusive determination regarding every fact which is at play. And the policy behind these doctrines is not really applicable here. As Mr. Barbetta covered briefly, this is not that proverbial second bite at the apple. This is not a case in which a litigant is trying to bring back the same exact case, but just coloring it as a different cause of action or something of that nature. So therefore, for that reason, as well as the judicial economy arguments, the board would respectfully request that this court reverse the Commonwealth Court's decision and remand it back to the Commonwealth Court for decision on the merits. Thank you.
Counsel, it's Justice Donahue.
Yes.
Let's assume that the Commonwealth Court reverses and the assessment determination is modified. What is the impact on the other cases that are pending in the Court of Common Pleas with a final judgment?
If I may, are you basically getting at the question you asked for Mr. Barbetta, that what happens to the other order? It's basically the board's position that it's one assessment. So therefore, it affects the Commonwealth Court's decision would affect that assessment. So it would have an impact across those two.
So is an appeal by one taxing authority an appeal as to all taxing authorities? Will all other taxing authorities be bound by what happens in that appeal?
Yeah, we would agree with that because of the fact that it is one assessment of that property. Therefore, that Commonwealth Court decision would have that effect on those other authorities.
So from your perspective, it's not necessary for every taxing authority to appeal if one appeals and they agree with the predicate for taking an appeal.
Yes, and that's our position here is essentially that the school district took a timely appeal of the order that was applicable directly to them.
Okay, thank you.
Thank you.
Thank you. We'll hear from Aplt, Mr. Fiorello.
May it please the court. My name is John Fiorello. I represent the Aplt, Houston Properties. Obviously, Houston Properties agrees completely with the Commonwealth Court's decision and rationale set forth therein. Admittedly, this case is somewhat unique in that ordinarily there is one appeal in which all the taxing authorities do intervene in the case if they desire to do so. In this case, there were two appeals, one initiated by the city, one initiated by the school district. However, all the parties entered their appearance and intervened in the other's cases. And as the court is aware, once you intervene, you have all rights of appeal and to participate in the action. And from the beginning, the cases were consolidated only for trial. They proceeded in tandem to the Commonwealth Court once, where they were remanded. And after remand, the trial court reissued an orders in each case. The only difference between the two orders was the docket number. They were identical, and the cases maintained their separate identity. Interestingly, the school district was very active in the city's case. 28 docket entries, so they were fully invested. They fully had the opportunity to appeal that should they have desired. They did not. No one did. So as a result, there's a final order.
Mr. Fiorello,
Let me ask you this, Mr. Fiorello. Res judicata precludes relitigation of an issue that's been finally litigated. Has Houston's nonprofit status become final?
Yes, it has.
How?
It has final because in the city's appeal, the trial court issued an order, and that order was not appealed. So there is a final order that deals with the exemption status of the property in question that is currently of record in Chester County. No one appealed that order. It is final and dispositive. So what if the school district's appeal, if there were anything else to other than an affirmance, you would have conflicting orders on the same property with respect to the exemption status. It creates an irreconcilable conflict.
Counsel,
can I follow up?
Again, but let me get back to my questioning of your opposing counsels. How could it be otherwise that given that you're dealing with one assessment in all of these cases, by operation of the statute that allows taxing authorities to intervene and participate in appeals, even if they are parties and things of that nature, doesn't that lead to the conclusion that in reading this statute and the way it operates, that an appeal by one taxing authority is an appeal as to all taxing authorities? I mean, if another taxing authority disagrees with the fact that an appeal was taken, they could get into the appeal on the other side of the V. But if they don't, it's an indication that they're willing to be bound by the outcome of the appeal that has been taken. And if the other taxing authority is successful in that appeal, it has to impact all of the other pending cases because there's only one assessment.
I agree completely with Justice, with your Honor. That is the case in this incident. In the city's appeal, which was initiated by the city, the school district had the right to appeal. So did the Board of Assessment, Mr. Long's client. They did not. So therefore, they did not avail themselves of the right. There is a final order.
You're coming to an exactly the opposite conclusion of what I am. Coatesville Area School District did file an appeal. Yes. That appeal can be taken to conclusion, and there's going to be a determination of whether or not the decision on the assessment and the exemptions was correct. That appeal by that one school district is going to impact all of the cases that are still pending. It's not necessary, as I read this statute, for everyone to appeal or for everyone to intervene. They can if they want to, but if one appeal is taken by any of the taxing authorities, it's going to be binding as to all of the other pending cases.
And I agree with that, what Your Honor said. However, the issue in this appeal, in the school district's appeal and the city's appeal, were identical. They were the same, the tax exemption status. And there is a final order entered with respect to that. And if you go through the elements of res judicata and collateral estoppel, it satisfies every single element to the T, so that the school district had the opportunity. It is the same parties. It is the same issue. And right now, there is an order. So there is a final order in Chester County. When you refer to it as pending, I would respectfully disagree with that. Sorry.
No, I'm sorry. It's Justice Bear. I want to follow up on Justice Donahue's if that's permissible. If Justice Donahue, that's okay.
Sure.
What I wanted to do, and again, I find your argument distressing, frankly, because the legislature thought of this. 53 Pennsylvania Consolidated Statutes 8847, which is part of this law, the Consolidated County Assessment Law. It says that if there's an appeal, that the changed assessment in computing taxes imposed for the next fiscal year will be binding upon all parties. So apropos what Justice Donahue's saying, and I have a second question for you, but apropos what she keeps saying to both sides, and I think she's absolutely correct, and respectfully, I think you're absolutely wrong. The legislature contemplated this. The legislature said if one party takes an appeal, we're not going to have disparate assessments for various taxing bodies. All taxing bodies use the assessment provided by the highest tribunal that decides the matter. So there is nothing inconsistent. And if the school district, if we send this case back, which is how the questions seem to be pending, and the school district prevails, there's no problem whatsoever. Now, what am I missing?
That there is a final unappealed order that already addresses this.
And I guess respectfully, so what?
Well, the exemption status has already been established. It's done. The case is over. And if you go through the elements of res judicata, there was nothing preventing the school district or the county or the Board of Assessment from doing an appeal of the city's case. The cases had gone in tandem the entire time until the most recent order. And so what'll happen is, let's assume that it goes back and there's something other than an affirmance. So you'll have a case that says the school district's appeal, it sets it at 50% instead of 75% of exemption or non-exempt, whatever, something different. So you'll have eventually a final order, and that order becomes final. So you have a final order in that case, and then you have a final order in the other case where both parties were in. It creates an irreconcilable conflict between the two.
And I think that's what Justice Donahue and I are both asking you. Maybe you've answered it, and I certainly don't want to be adamant about it. But it seems as if there is no conflict. Commonwealth Court decision wins unless we change it. And we would have the right to accept an allowance of appeal and to change it. But and if SCOTUS changes our decision, then that's what wins.
Respectfully, though, Your Honor, once an order is final, you're going back and changing a final order in another case.
Well, I'm sorry. Go ahead and finish your answer. I apologize.
No. I didn't mean to interrupt.
No, no, no. And I didn't mean to interrupt. But my other problem here is that the way I see this, and I appreciate you're going to disagree, you're a fine advocate and doing a good job, but I want to give you the chance, is there is no prior case. When the Chief Justice introduced this, and when we all heard about it in the first appropriate law school class, for these preclusion principles to apply, there has to be a prior case and a subsequent case. And it seems to me you have two simultaneous cases, and therefore the most basic element of these principles is not present.
Respectfully, I believe that's a distinction without a difference, because in this case, temporarily, the other case that was going in tandem is now a prior case. So let's assume it gets remanded for some reason to the trial court. The trial court has to take some additional testimony, or we're retrying it again. There's already been a decision. So there is right now a prior decision, or under collateral estoppel, it's already been decided. The issue before the court has already been decided.
Well, here's before our court.
Pardon me?
That's the only thing we care about. It's whether res judicata was applied by the Commonwealth courts to thwart the school district's right to appeal.
Well, it's res judicata and or collateral estoppel. So is the issue decided?
How can you employ res judicata to block someone's right to an appeal?
Because they had the same right as all other parties to appeal the city's appeal. It's the same issue, the same parties, and they actively participated. Any intervener in a case has the same rights. In fact, this court goes so far. You dealt with this in the Muncie case. Appeal of municipality of Penn Hills, where once an intervention is allowed, the intervener is afforded all rights of a party to the action. And unless otherwise specified in the intervener's right to participate in an appeal, is not contingent upon the continued participation of the original appellant. So that if the city decided not to do it, not to go forward, they had the right to pick it up. The fact of the matter is, I don't know why they didn't communicate or they didn't, but they didn't. And they had the right to do it. So, and this court's jurisprudence, stretching all the way back, is very consistent. If it's not consolidated entirely, the cases retain their separate identities for purposes of an appeal. So now you have a final order in one case, and that one case establishes the issue that is in the other case. So I think right now it's them getting a second bite at the apple for something they didn't do, which they should have done, and they had an obligation.
The argument is now becoming repetitive, so you've adequately made your points. Unless there's some other questions, we'll conclude the argument. Hearing none, we thank you.
Thank you very much, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
This matter is the Commonwealth of Pennsylvania versus Eric Yale. Representing Eric Yale is Mr. Jules Epstein. Representing the Commonwealth of Pennsylvania is Mr. James L. McMonigal, Jr.
Good morning. Mr. Epstein, appeal was allowed in this criminal case to consider the test for determining when a defendant can introduce evidence to suggest that a third party committed the offense with which a defendant has been charged.
Thank you. Mr. Chief Justice, may it please the court. Eric Yale's jury had a single question to resolve. No one disputed, and it could not be disputed, that the methamphetamine paraphernalia found in his house was the responsibility of Larry Thompson, the man named in the search warrant, the man hiding from police in the closet. The only other question is, was it Mr. Yale's also? He testified, no, it wasn't. But he was deprived of the right to present the type of evidence that this court has said for 99 years is absolutely allowed. Relevant evidence tending to show that another person committed a crime. Relevant evidence that is mandated by the Constitution. What was that evidence? Not one, but two prior instances of Larry Thompson taking advantage of being at someone else's house and using that as a subterfuge to operate his methamphetamine business. The errors here are simple. The Superior Court applied a test that this court has already repudiated, saying the other acts must be like a signature. The Commonwealth repeats that error and makes two more. It says in Pennsylvania, and there's no support for this, Rule 404B must be equally applied to the Commonwealth and the defense. And the Commonwealth completely misreads the constitutional mandate found in Holmes and the other United States Supreme Court cases. And while this is not a constitutional claim, obviously, Pennsylvania may not have a rule of evidence that flies in the face of the constitutional right to present a defense. As I explained, the proffer made in the middle of trial and based on a single fundamental principle, that of relevance, was to have each of the two police officers who had found Mr. Thompson doing this same thing before, essentially saying, here it is. And that was denied. What is this court's case law? 99 years ago, in a case called Loomis, this court said that type of evidence is admissible if it meets the relevance standard and supports the tendency to prove. Boyle, relevance standard. Ward, 1992, relevance and, as pertains to this case, admissible if it supports the defendant's testimony. 1993, McGowan, relevance. And I will ask this court to permit me to discuss McGowan for one more moment, because McGowan absolutely controls this case in terms of when are other acts sufficiently similar to mandate admissibility. Mr. McGowan was charged with the robbery of a pharmacy. All he wanted to show was that in other pharmacy robberies, no signature, nothing like that, he had been misidentified. The evidence was excluded. The conviction was overturned. That is as parallel to this case as one could imagine. There were other crimes of that ilk. And here, of course, there is more. I will confess, this court has used varying terminology, highly detailed, substantial similarities, or going back to Ward, as long as the evidence is relevant. I suggest when you look at the meaning of them, they're all the same. They are the Rule 401 relevance standards of tends to show. As I said at the beginning, the Superior Court's error was simple. They demanded signature. Well, we already know that's wrong. Why? And this also goes to the point of the Commonwealth's error in equating 404 as being equal for the defense and the prosecution. In 2016, this court decided the Hicks case, which was prosecution use of other acts evidence against a defendant. What did the court say? Had to be a signature. In 2018, and I argued it, this court decided Gill. And while Gill was ultimately decided on the grounds of abuse of discretion, this court made a statement that we've already accepted a lower standard for other acts evidence, the substantial similarity test.
Mr. Epstein, Justice Baer, you make the case. You okay?
Yes, sir. I apologize. I dropped a piece of...
No, that's okay. Are you ready to go?
Yes, absolutely.
Okay, thank you. You make sort of the opposite position from what I thought confronted us. It seemed to me that stare decisis was against you. And I looked at the Superior Court's decision in Rinnie, and I thought it was a Superior Court decision in McGowan, and I thought we had affirmed the highly detailed similarity, substantial similarity, high signature crime language in both Patterson in Weiss in 2013, Patterson in 2014, admittedly without full analysis. But I thought that the weight of Pennsylvania law is against you. You're suggesting that the strong weight of Pennsylvania law is with you, and the Superior Court just erred in this case.
In this case and in a series of cases, a couple of things. Rini was a Superior Court case. And if you go through the brief, the Superior Court has, on different cases, used different tests. But Justice Baer, respectfully, you authored the Gill case. And you did not apply the signature test. You made it clear the signature test did not apply here. Beyond that, and I say this most respectfully, this court at various times has used different terms: substantial similarity, highly detailed similarity. But it has never said signature. And what has to inform those words, because respectfully, it's like beauty. Highly detailed, substantially similar, it's in the eye of the beholder. So what we need to do, if I may respectfully,
sure, please.
What we need to do is look at how has that been applied. And that's why I say, please look at the facts of McGowan. Because McGowan, again, used the substantial similarity test, but all that it needed for substantially similar was other robberies of pharmacies. Because
this is Justice Donahue. Justice Cappy in McGowan, and I agree with you, the facts of the case are what they are, which is to be nothing other than similar crimes. But Justice Cappy started down this slippery slope by adopting the language from Rini, which really had nothing to do with the facts of McGowan. Because he noted with approval, the court noted with approval, the highly detailed similarity standard. And I think that's what started down this slippery slope. And my question to you is, why would evidence have to have highly detailed similarity or detailed similarity if the only test is whether or not it has a tendency to prove that someone else may have committed the crime?
So I happen to agree with that. I will explain that I think that language actually comes up to distinguish it from something that is so remote or tangential. And if I may, Justice Donahue, the United States Supreme Court actually grappled with that in the Holmes case. And again, this isn't a constitutional case here today, but of course it informs us. When the United States Supreme Court, and this was Justice Alito writing for the court as a unanimous court, talked about this in Holmes, he went on to quote from traditional treatises or horn books on what is sufficiently similar in a homicide case. And he wrote, evidence tending to show the commission by another person of the crime may be introduced unless it's so remote or lacking in such connection. So to me, that's really what the similarity test means. It has to pass the relevance test. The other language that he used is the accused may include any legal evidence tending to prove that another person may have committed the crime. And the only time it may be excluded, and this is verbatim, is where the evidence is speculative or remote. And the Third Circuit in a case called Stevens said it has to be sufficiently similar to the crime at bar so that it is relevant under 401 and 402. So,
Counsel, Justice Doherty.
Good morning.
So as we understand that our case law is all over the place, how would you distinguish the standards without the contextual language of the statute between third parties and defendants, understanding that the statute 404B is defined as quote unquote person?
So
what is your position?
My position is two parts. One is there's a question as whether this should be 404B or simply 401, or if 404B, when read, needs to be filtered through 401 when it is the defendant. Because clearly there is an asymmetry written right into 404B. Why? We have a notice provision only for the prosecution. Why? We have a prejudice analysis. The prejudice that rule historically was developed for was prejudice to the accused. Because obviously when a jury hears the accused did something wrong before, there's a character message notwithstanding any non-character purpose. There is no correlate prejudice to the government. So I hope I'm answering your question. I think I understand you, Justice Doherty, that inherent in that rule is an asymmetry. And again, Hicks, which if I recall, you wrote the majority opinion in, was the signature test. Justice Baer, for the defendant, was the lower test. So that's in our case law at all. So whether you call this a Rule 404 case with some asymmetry, or you call it Rule 401, the bottom line is 404B has to be interpreted through the filters of relevance and the constitutional right to present a defense. And this Commonwealth's common law right to present a defense for it to be read fairly.
So if you, I'm sorry, Justice Doherty, you done? Okay. You're muted again. If you put on your professor hat for a second, and with greatest respect, and you know this, it's far less important if your client prevails or not than if we straighten out Pennsylvania law. That's our principal function, and we said that several times today. If we change the highly detailed similarity, signature crime dichotomy to sufficiently similar as to be relevant, are we consistent with how you view the case?
Absolutely.
Okay, fair enough. My recollection of Gill, and I'll have to go back and look at it. People ask me about cases I've written. I don't have to tell them. I have to read it. But is that we didn't get to the test, that we thought the case did not include it. Am I wrong?
You are correct.
Okay.
But if I may, footnote 4. So just when you're kind enough to go back and refresh your memory, footnote 4 says, but we've already made clear what the test is. And it was not signature. That's all I'm saying. Admittedly, dicta in the case, but a specific acknowledgement that it wasn't signature. That's all.
Thank you very much. I got it.
Thank you, Mr. Epstein. We'll hear from the Commonwealth.
Fundamental right to present a defense, but that right is not absolute. The U.S. Supreme Court has recognized that the Constitution permits judges to exclude evidence that is repetitive or marginally relevant. A defendant's fundamental right to present evidence is not a right to present any evidence. There is limits. The question in this case is what those limits are when the defendant is claiming someone else committed a crime. The Commonwealth begins with the rule. Rule 404 says that generally, evidence of someone else's crime or bad acts is not admissible to prove their character in order to show they acted in accordance with that character trait. However, if the crime or bad act is being proffered to prove motive or a common plan or signature crime, it may be admissible. Interestingly, the rule states only one standard for admissibility. It does not provide a different standard based on who is proffering the evidence, yet that is what the defendant is asking for. The Commonwealth submits the defendant's request to establish a different standard is wrong. The Commonwealth submits that there is no such thing as reverse 404B evidence. It is simply 404B evidence. That is how the rule is written. Such evidence is admissible if it is established that one of the exceptions to the general rule of inadmissibility applies. In this case, it is the common plan or signature crime exception. That exception requires the offering party to prove sufficient similarities between the alleged crime and other bad acts to be so similar as to be a signature crime. The defendant says that is a standard that violates the right to raise a defense. However, the U.S. Supreme Court says the Due Process Clause allows some limits on the right to present evidence.
Counsel, could I jump in? I think you've
Certainly, Judge. Certainly, Your Honor.
Free time. The signature crime standard that you want us to use is a line of cases the Superior Court's developed for the 404B cases. Why does 404B have any application to a case like this where Yale is trying to get in prior offenses of Thompson? Looking at 404B, the concern obviously is the propensity suggestion, the character suggestion. Why do we care anything about Mr. Thompson's propensity or character? It has nothing to do with this case, suggesting that 404B is a complete red herring. Do you follow my in other words, this is not evidence of Mr. Yale's character, Mr. Yale's propensity, which is the concern of 404B. Trying to cram the 404B paradigm onto this case seems ill-fitting, given that we don't care at all about third parties, about Mr. Thompson or any other person that Mr. Yale would want to say committed this crime or could have committed this crime.
Well, Your Honor, what I would say is that 404B clearly deals with evidence of crimes, wrongs, or other acts. So Mr. Yale was trying to introduce someone else's prior crime or prior bad act. So Rule 404B does apply.
The concern about showing that Mr. Thompson acted in accordance with character or with the Thompson propensity to engage in bad acts is wholly immaterial and irrelevant to a case against Mr. Yale, isn't it?
Well, then why is Mr. Yale introducing it? If it's not relevant, it's not relevant.
To negate guilt under 401 for the relevance is to negate his guilt. Isn't that what the Holmes case that Mr. Epstein was discussing would suggest that if you or I or anybody's charged with a crime, it's obviously highly relevant if we can present evidence that Mr. Smith or Mr. Jones was actually the person who committed the crime. The law has no concern about what this says about Mr. Smith's or Mr. Jones' character, because the jury's not weighing their character to prejudice them.
No, the jury's not weighing their character to prejudice them, but the jury is still deciding whether or not someone else's alleged crime or bad acts is sufficiently similar to say that Mr. Yale, I'll just use Mr. Yale, committed this crime. It's not enough to say that there were 4 other burglaries in the jurisdiction yesterday on the same day I'm accused of committing my burglary. What's relevant about just 4 other burglaries generically?
Just one more question on that. You would certainly acknowledge, would you not, that the evidentiary hurdle to get to the fact finder for 401 relevance is considerably lower than the hurdle that's been set up by the Superior Court and other courts for 404B signature crime evidence. Would you agree with that?
I would agree with that, Judge, or Your Honor, and I would say that 401 is the general relevance rule, and you work from, as every law student is taught, from general to specific. So when you're dealing with the specific type of evidence, such as a prior crime or a prior bad act, you look to 404B because that deals with the admissibility of that type of evidence. So the defendant, whether it's Mr. Yale or Mr. Smith or Mr. Jones, needs to show something more than just, well, there was 2 other rapes in the jurisdiction last night on the day I was accused, so it must not be me. I'm innocent. That is too speculative.
One thing we could stipulate, it's not Mr. Harvard, because everybody knows he's guilty. Never mind.
Counsel, Justice Baer, I'm not assuming that your client, that the Commonwealth wins or doesn't win. That's an application of facts of the case. I'm interested in what you think of the test that opposing counsel said that they would be satisfied with if we are going to go away from signature crime and highly detailed summary. What I suggested to Mr. Epstein, which he said was okay with him, is sufficiently similar as to be relevant. Now, what do you think of that test?
Quite honestly, Your Honor, I think it's a little low. One of my positions, and as I think I set it forth in my brief, is sometimes defendants use the due process clause as a sword to try to avoid generally applicable rules to everybody.
Always. So we understand that.
Right. The rules should be the same for whether the Commonwealth is admitting the evidence or the defendant is admitting the evidence. The Commonwealth submits that the main purpose or the main difference could be the amount of prejudice. Obviously, this type of evidence can be very prejudicial to the defendant. As Justice Weck indicated, if it's a third person, we're not worried about the prejudice necessarily to that person, but there's still a question of prejudice to the Commonwealth, which may be a difference in degree, but not in what the type of evidence should be admissible to the jury once you get past the signature part of it. Is it then too prejudicial for the Commonwealth? Will the Commonwealth be able to sufficiently rebut that evidence or not? Is it too prejudicial in that sense? And again, to go back, just to say, well, there was a robbery the other night, on the same night I committed a robbery, that really doesn't, the Commonwealth submits, that doesn't even get to the general relevance.
Counsel, I think arguably that would not be relevant. But again, you have a test and then you have the application, which is better suited to trial courts. If we, and again, I'm just, because I appreciate your thinking out loud, if we add a prejudice component or a confusion component to that test, is at least you at this moment in time thinking off the top of your head satisfied with that?
Well, off the top of my head, and prejudice is already in the rule, Your Honor. It does. In a criminal case, this evidence is admissible only if the probative value of the evidence outweighs the potential for unfair. So that's already part of the test. I think what we're quibbling about here is the part one of the test. When is the evidence sufficient enough to even get to the jury or go to the next step of the prejudice.
Right.
And again, as I said, excuse me. As I said, there has to be more than just, well, there was another robbery last night. And even in McGowan, I think the main issue there was the defendant was misidentified, not so much that the question was there were other crimes, that the main issue was a misidentification. And in the Holmes case, the Commonwealth submits that the Supreme Court quoted with approval the Gregory case, where the Gregory case from South Carolina said there needs to be such a train of facts or circumstances as tends clearly to point out such other person is the guilty party. So there needs to be more than just, well, it's a burglary. Well, what about the burglary? And again, as you suggested, Your Honor, it might be we're talking about the application in the trial courts, but there needs to be some similarities to the crime, and the Commonwealth would submit the text should be the same, a signature crime.
So can I ask you a follow-up on that? You mentioned in response to one of my colleagues that this evidence proffered by Mr. Yale or some defendant in some other case would be offered as a shield. I thought that was, I'm sorry, as a sword. I thought that was interesting because the Second Circuit in the Abu Musalem case, quoting Dean Wigmore, by the way, held, we believe the standard of admissibility when a criminal defendant offers similar acts of evidence as a shield need not be as restrictive as when a prosecutor uses such evidence as a sword. Isn't this case one in which Mr. Yale is seeking to use the evidence of Mr. Thompson's bad acts as a sword for the defense of Mr. Yale in this case, rather than the 404B cases where the Commonwealth seeks to use the 404B evidence as a sword against the defendant being prosecuted?
I would say yes, but Mr. Yale is using it as a sword against the Commonwealth to claim the Commonwealth has not carried its burden or to point blame to someone else for the jury to find a reasonable doubt in Mr. Yale's guilt. To me, quite honestly, it almost seems to be a distinction without a difference. Mr. Yale's still using evidence to combat the Commonwealth's presentation of evidence and the evidence against him. And there must be some level of similarity to give the jury something to hang their hat on. And just to say, well, it's the same one-pot method. Well, the one-pot method is like baking a cake. All the ingredients of the cake go in, all the ingredients of the one-pot method go in, unless, just like many of our grandmothers may have had that secret ingredient in the cake to make it taste better than Aunt Jane's. Baking a cake's baking a cake. Making meth is making meth if you're using the one-pot method. So there was really nothing all that similar in this case here. So the trial court did not agree.
Mr. McGonigal.
I'm sorry, Your Honor.
We certainly understand your argument.
Okay.
You've covered it very well from every angle. And again, we have the case. Unless there are any other questions, we can conclude the argument. Okay, thanks to you. Thanks, Mr. Epstein. We're going to take a recess until 1 o'clock. We're going to try to have counsel for the next case ready at 1 o'clock. So with that, we'll take our break.
Thank you, Your Honors.
Thank you.
Thank you.